Welcome to our channel and thank you for clicking on this video. This is video 4 of 4 regarding the South African Employment Equity Act. If you are an employee representative on an Employment Equity Committee or Grade 12 learner, you will benefit from watching these videos. Please note that this video is not a complete summary of the Act. There are other videos on this topic as well. New law may also come into play after the publication of this video. Monitoring, enforcement, and legal proceedings as a result of the Employment Equity Act. The Act protects employees who exercise their rights and obligations under the Act against victimization, obstruction, and undeserved influence through monitoring, enforcement, and legal proceedings as follows. Monitoring. Employee or trade union representatives can monitor contraventions of the Act and report it to relevant bodies. Any employer's policy or practice showing favor, prejudice, or bias against individuals may be the basis of unfair discrimination. Please refer to video 2 regarding the responsibilities of an Employment Equity Committee representative. Direct discrimination is easily identifiable and involves observable differential treatment that violates a person's dignity. For example, an employer follows a policy of remunerating women employees on a lower scale without justification, whereas male employees are remunerated at a much higher scale for doing the same work. The CCMA website provides very valuable information regarding discrimination. Powers of the Labor Inspector. Labor inspectors are authorized to conduct an inspection as provided for in Sections 65 and 66 of the Basic Conditions of Employment Act. Undertaking to comply. If the inspector has reasonable grounds to believe that a designated employer has failed to comply with its obligations in terms of the Act, the inspector will obtain a written undertaking from an employer to comply within a specified period. Compliance order. If the designated employer refuses to comply with the written undertaking, the inspector will issue an order to comply. Review by Director General. The Director General may conduct a review to determine whether an employer is complying with the Act. On completion of the review, the Director General may make recommendations for compliance within certain time frames. Powers of the Labor Court. The Labor Court has the power to make any appropriate orders, award compensation, or impose fines. Stricter employment equity laws can be expected for South Africa in 2022. In November 2020, Parliament's National Assembly has passed the Employment Equity Amendment Bill and has sent the draft law to the National Council of Provinces for concurrence. The bill will allow the Employment and Labour Minister to set employment equity targets for different business sectors. The Minister can set targets for different occupational levels, subsectors, or regions. The new law also aims to reduce the regulatory burden on small businesses and add rules for doing business with the government. Certain companies will not need to comply with Chapter 3 of the EE Act anymore. Companies still deemed designated employers will need to prepare a new EE plan for 2022 going forward as per the new amendment to the Act. The new sector-specific equity rules will be applicable if and when the President signs the bill into law at a projected date in February 2022. This brings us to the end of video 4. We hope you found it helpful and that we will see you in one of our other videos soon. Please subscribe, like, and share.